In England, the legal system is based on common law. Over the centuries, English judges have unified and developed laws using a system of precedent and established practice. By contrast, in the rest of Europe, civil law forms the basis of most legal systems. Civil systems generally feature a code setting out basic rights and duties, and in some cases can be traced right back to Roman law. In 2004, the BBC's Unreliable Evidence set out to explore the differences between the two systems. Here's presenter Clive Anderson introducing his panel of experts.
To discuss laws common and uncommon, civil and uncivil, I'm joined by Konrad Szyman, one of the English judges at the European Court of Justice. Hugh Mercer is a barrister specialising in EU competition law, public and private international law. He's appeared in cases involving the European Commission. Professor Basil Markasinis, who has joined us on this programme before, is a leading expert on comparative law. Professor John Bell is another distinguished academic expert, currently Professor of Law at Pembroke College, Cambridge. Well, a distinguished panel. Professor Markasinis, how would an ordinary person, maybe an ordinary litigant, recognise the difference between a court with historical basis of the civil law or the common law?
I would have put it in this way. The oracles of the law, the people who tell us what the law is, in the continental European systems are the academics and the universities, and in the common law system are the practitioners and the judges. And that's a very important difference, because academics go for system and logic and structure and theory, and they therefore tend to be system builders, whereas our lawyers are practitioners. They look for the problems and they try to find the right remedies, so they are problem solvers.
Would there be a sort of analogy to be drawn there between the way perhaps a town or a city might develop in England using old roads and gradually building up, as opposed to a new town which was laid out on a grid pattern?
Yes, I think it's true to say that our system has developed incrementally without the kind of sort of structure that the European systems had from the beginning, largely for the reasons you said, the inheritance of Roman law. But these differences are being attenuated in practice. And gradually, I think, we're all moving together. There's a give or take. We are adapting to their ideas, and they are taking many of ours.
Can I just talk to Professor John Bell? Now, I've mentioned that under the civil law system, greater respect is given to academic lawyers. So do you look forward to your views as a professor of law having more weight, possibly, with English judges as they approach their judging?
Well, certainly some English lawyers are having considerable weight with English judges already. And I think the pattern in what are called civil law systems is actually quite variable. In the areas that I specialise in, which are administrative law and public law, most European systems are actually judge-made in developed principles. Often the main doctrinal writers are practitioners and not academics.
So this blurs the distinction then.
That blurs the distinction. I think it depends very much on the branch of law that you're operating. In private law, that has tended to be developed from Roman law. Those principles were taught first in the universities and then exported to the practitioners. In public law, which is the base for the European Convention on Human Rights, and also in constitutional law, which relates as much to the European Union as well, there are influences very much from the practitioners, and there's a debate between the practitioners and the academics, which is a very fruitful one. So I think what is happening already is that within the civil law systems there is much more of a mix than perhaps is characterised by the stereotypes that we often use.
Well, Hugh Mercer is a practitioner in this area of the law. Is anxious to say something?
If one looks at the European Court of Justice, where, of course, Judge Szyman sits, this court, particularly since 1973, has built up what is equivalent to a common law system, a system built up on decided case law, influenced by academics, but academic writers possibly don't have quite the same force as they would in the standard civil law system. A case which came to mind was the transoceanic paint case, one of the early cases on the right to be heard. The European Commission had taken a decision granting an exemption to a company with a particular condition attached to the exemption, and the company concerned had not been consulted on the content of the condition. And Advocate General Warner, the British Advocate General at the time, looked at the different systems, found the French and Belgian and Italian systems essentially lacking on this point, and lifted the audi alteram partem rule from English law, and then applied that as a rule of community law.
A very English-sounding rule that he brought in. Anyway, you're painting a good picture there of the valence of the law. But can I just ask Judge Sheeman in the European Court of Justice, does it make any practical difference to you, sitting as a judge there? Have you had to adapt your judging ways to fit in with the European way of doing things?
Very much so, indeed. The position here is very noticeably different at first blush in procedural terms because of the language problems. We are now a community of 19 different languages, which means that we may be addressed in any one of 19 different languages in court with simultaneous translations, which is a great inhibition in having the law hammered out in court in the same way as traditionally has been done in England.
Well, any flowery advocate would find that rather irritating to have his words translated, and a rather more precise construer of statute would equally find the arguments must tail off into translation points. Does that cause problems?
Yes, it does, which is why we tend to rely much more on written material, which too may need to be translated, but there is more time for the translators to get precisely the right word, and also for the national judge who happens to speak that language to be able to nuance it as required. But there is a language problem which affects partly the use of the actual words, but also in a rather cultural sense, also sometimes the cold conceptual way of talking. I think when I came here first, there was a slight amusement at the fact-based approach which the British have tended to bring to the court to move from the facts of a case to deciding the principle, rather than doing what in some ways strict theory requires one to do, namely to consider the point in the abstract, which is perhaps more in the French tradition.
So you're perhaps reinforcing the notion that the English legal system is more down-to-earth, more robust, less addicted to fancy theories?
Well, all this can be exaggerated. At the end of the day, all our societies face very much the same type of tensions, which it's the function of the law to resolve. Tensions between freedom of contract and protection of the consumer. Let moneylenders fix what rates they like, or lay down maximum rates. That goes back to the Romans. Tensions between freedom to demonstrate and freedom to walk along the road. Tensions between freedom of the legislator to lay down laws and the desire to protect the minority of the moment against oppression by the legislator. And we all tend to come up with very much similar examples, albeit by slightly different processes.
Professor Markasinis, would you say there's now what could be described as a convergence between the various European systems, the English system, French, German? I think are they going to come together under sort of body of European law?
I would most definitely think that there is a convergence. It's a gradual convergence. It's an incremental convergence, which actually suits our mentality, our legal mentality. Yes. And the reason why it's there is very simple. We see a convergence in tastes, in habits. Everyone nowadays drinks cappuccino instead of tea. We wear the same clothes, drink Coca-Cola, eat McDonald's. The tastes, the customs, the habits are changing, and so is the law. But in addition to that, you have the globalization phenomenon. You have the fact that more companies are operating across borders. And, of course, where companies go, lawyers usually follow.
Professor John Bell.
I would add two things to that. Firstly, in public law, we have very common rules in the European Convention on Human Rights, where people work together as a team in the court in Strasbourg to try and create rules which can apply to different countries, so that we are looking at cases now in England which are bits of litigation in Austria or in Turkey. So that's one thing. And the other thing is the importance of legal education and the way in which now we have elements of legal education which are common, and students who study in different European universities are coming from different European countries and beginning to understand each other socially as well as legally. And that creates a body of people who are able to work together to build a further European legal system.
And so it's a body of European law that's going to be developed, do you think?
There will also be national laws that will be different. There will be experimentation. There will be procedures that are different. But there are common values, there are common ideas. How we work those through in practice is often going to be different, just as within the United Kingdom we're used to the Scots and the Welsh and the Northern Irish doing things differently, say in education, from the English.
Fascinating to learn from that discussion how the English common law is changing and developing because of a cross-fertilisation with civil law systems.
Essentially lacking on this point and lifted the audi alteram partem rule from English law and then applied that as a rule of community law.
In England, the legal...
And applied that as a rule of community law.